The International Court of Justice, what the court did not do. There are three quite significant emergency provisional measures and comments the ICJ did not make. Firstly, the ICJ did not order an immediate suspension of military operations by Israel in Gaza, unlike what the ICJ did order against Russia in the Ukraine versus Russia case concerning an indication of provisional measures in that conflict. And there are possible reasons explored in this post later why the two cases were treated differently by the ICJ. In the Ukraine versus Russia case, the ICJ on the 16th of March 2022 stated the following. For these reasons, the court indicates the following provisional measures. By 13 votes to 2, the Russian Federation shall immediately suspend the military operations that it commenced on the 24th of February 2022 in the territory of Ukraine. The ICJ also made the second provisional order by 13 votes to 2. The Russian Federation shall ensure that any military or irregular armed unit which may be directed or supported by it, as well as any organizations and persons which may be subject to its control or direction, take no steps in furtherance of the military operations referred to in point 1 above. However, following significant and historic observations that there is a plausible genocide case against Israel, in the South Africa versus Israel case, the ICJ on the 26th of January 2024 did not order Israel to immediately suspend its military operations in Gaza, despite this being one of the main provisional measures requested by South Africa. The ICJ stated the terms of the provisional measures in this way. For these reasons, the court indicates the following provisional measures by 15 votes to 2. The State of Israel shall, in accordance with the obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A. Killing members of the group, B. Causing serious bodily or mental harm to members of the group, C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D. Imposing measures intended to prevent births within the group. And the ICJ also made this second provisional measure, stating the State of Israel shall ensure with immediate effect that its military does not commit any acts described in point 1 above. Now, many legal scholars and many in the public may argue that this amounts to an effective and immediate suspension of Israel's military operations in Gaza. That view is not universal for several reasons. Firstly, the court could have used these operable terms in the order Israel shall immediately suspend the military operations in Gaza, but chose not to, despite South Africa's specifically worded drafted order in its application to that effect. Secondly, a reading of the provisional measures while reiterating a strong warning and a reminder to Israel to prevent any genocide and to punish those who do commit genocide did not order Israel to halt its military actions in Gaza. Thirdly, and if you think about it, if it had made a provisional order to that effect, that there would have been another round of votes that had taken place in Parliament and the United Nations for a ceasefire. That hasn't happened yet. So why did the ICJ not use the phrase that Israel shall immediately suspend military operations in Gaza or words to that effect? This is what I suspect. Firstly, the court only had jurisdiction on one party, Israel, and not Palestinian armed groups. And I suspect the ICJ were convinced by Israel that no such order should be made which in effect would bind the hands of Israel but not others to this conflict. It also appears the ICJ were also convinced that the situation on the ground with the parties involved is markedly different in the case of Ukraine versus Russia, where both parties can be bound by provisional measures of the ICJ. But moreover, it may be in the Ukraine versus Russia case was brought by Ukraine to halt military action by Russia based on a false claim made by Russia that Ukraine was involved in genocide in a particular region of Ukraine. And thus the ICJ made a provisional measure for immediate suspension of Russia's military action. Given these reasons, the ICJ further found it necessary to say this, to summarise, to emphasise that all parties to the conflict in Gaza Strip are bound by international humanitarian law, and that it was gravely concerned about the fate of the hostages, calling for their immediate and unconditional release. Now, whatever the reasons were, the order made is unlikely to provide on-the-ground immediate comfort to the people of Gaza, who had hoped the World Court would have ordered provisional measures to immediately halt military action and add pressure on world leaders to stop any military action and aid they may provide their ally. And yes, it's a huge victory to South Africa to have convinced the ICJ of a plausible genocide case against Israel to answer and not have the case thrown out. But the provisional measures were so ordered without those operable terms: immediate suspension of military action as per the ICJ's provisional ruling. This can explain why some pro-Palestinians feel understandably very disappointed with the ICJ's ruling on the first and second provisional measures ordered, and why Israel understandably is keen to demonstrate it is engaging in its military operations, abiding by international humanitarian law by noting the provisional orders. The second significant emergency provisional measure the ICJ did not make was an order on Israel to grant access to some kind of independent fact-finding mission as requested by South Africa. This was, in my view, a mistake and a missed opportunity to connect provisional orders to find out and evidence gather exactly what is happening in Gaza, and which would have also connected with the separate investigation ongoing at the International Criminal Court. And thirdly, with a very close inspection of the ICJ ruling, you will also have discovered the ICJ avoided making any provisional comment or reference to the following issues. 1. Israel's right to defend itself and the use of force in occupied territory, a point which was mentioned by both sets of advocates in the case and which is often used as a reason for Israel's military actions. This is going to be a very important issue for ICJ to rule on. And further, while some statements were referred to in the ICJ's ruling, particular biblical statements by leaders in Israel were not. That might meet genocidal intent. Why they didn't make these orders and comments? Well, feel free to make your comments in the comment section. Subscribe to Community Station for more. Feel free to comment, follow, like, and share.